Please, Your Lordship, I beg to mention item number 7, Your Lordship. We are taking adjournment for the day, Your Lordship. Lordship, on the last occasion we were appointed to represent respondent number 8, 9, 10, 12, 13, 14 and 15.
For respondent?
We are for the respondent 8, 9, 8, 9, 10, 12, 13, 14 and 15.
And who's for the petitioner?
No.
We
What
could
is
not.
this case about?
This is the appointment of Garu lecturer in various part of Garu Government College.
Accommodation has been sought for on behalf of the respondents.
Number 8, 9, 10, 12, 13, 14 and 15, Your Lordship.
8, 9, 10, 12, 13 and 14. On the ground that the Learned Council
We could not collect the file from the previous counsel since she was out of station.
has just been appointed recently on their behalf, and the brief could not be produced accordingly. On preemit, seems allowed. This is matter of the
After 3 weeks, Your Lordship,
3 weeks.
we have to collect the file and prepare the case, Your Lordship, from the previous counsel.
2 weeks.
Oblige, Your Lordship.
Do it. Otherwise, next time no adjournment will be given.
Oblige, Your Lordship.
Your Lordship, may I mention item number 16? Can this matter come after 2 weeks?
Sixteen.
16, Your Lordship.
No objection, Your Lordship.
How long?
2 weeks' time, Your Lordship.
On pre-made by the appellant. This is matter of 2 weeks.
Oblige, Lordship.
May it please your Lordship. Lordship, I beg to make a mention of item 8 and 9, Lordship. These are connected matters, Lordship. Lordship, I'm praying for some accommodation. If these matters may be listed after a week's time, Lordship.
On pre-made by the petitioner. This is matter of the 2 weeks.
It's highly obliged, Lordship.
From daily cost list, item number 1.
Lordship, this matter pertains to the first inquiry of the suspended CM of Langren, whereby your Lordship had, and the other matter had heard the matter at length. Now, that order will have some bearing in this case.
How is it connected here?
Lordship, in this matter, there was a first complaint against him in the year 2018.
Okay.
Now, inquiry was held and I was reinstated. Now, against that inquiry, they have challenged before this court. So now, because now he's again suspended, now there's a second complaint.
But that would not have, see, that it may
Lordship, in this case, what
it may
happened is-
pertains to the same person,
Same
but
person.
not necessarily, in that order.
No, but basically, your Lordship, it's the same district council who had reinstated me, and now it's the same district council who has suspended me. So, Lordship, may kindly, if it can be listed after 2 weeks, we'll wait the outcome of the other matter.
On you are for?
I'm for the respondent number 4, Lordship.
You are what?
And for the petitioner, your Lordship.
What is your submission?
Lordship, same submission. I'm praying that this matter may come after the pronouncement of judgment in this WPC 279 of
Might
2023.
take some time. We don't know.
Your Lordship, after 2 weeks.
Then the council of the parties has submitted that a similar matter involving the parties hearing is pending Announcement of judgment by this court. Which judgment, if so pronounced, would have a bearing on these proceedings? Accordingly, it is prayed that some time may be allowed. It is prayed that this matter may be adjourned in the meantime. As prayed for, this is matter of 3 weeks.
Because Lordship, the legal issue here also is that the complaint, we had raised that ground that the complaint should be placed before the Darbar. So that issue is also in the other matter. So that's why Lordship.
Fine.
Obliged.
Item number 2.
Please, Your Lordship, this is a cantonment matter. Respondent number 3 and 4, they have already filed an affidavit.
From before Inner India, I didn't have any instruction till date. So I'll be depend on the cantonment board.
Who is 3 and 4?
3 and 4 is a cantonment board.
Cantonment.
Shillong
You are
cantonment.
there. Mr. Devnath, you are appearing for?
For the Union of India.
This is with regard to that notification? With regard to the FSI?
Says,
Lordship, please extend the interim order.
The respondent number 3 and 4 has filed their counter affidavit. However, as far as the respondent Union of India is concerned, Mr. R. Devnath Laird, CDC, has sought for some more time for the said affidavit, counter affidavit to be filed on the ground that relevant instructions have not yet been received. On pre-emit, the respondents 1 and 2 are directed to file their counter affidavit on the next date, within the next date fix. What is the interim order here?
So, impugned orders had been stayed, my lords. The impugned order, Lordship will find at page 37.
Is it required to pass an order in that regard every time the case is listed?
I believe Lordships, if it is an order which is till further orders, that extent, then it's fine. Then it's fine.
I believe so. What is the first? Yeah, till further orders.
Lordship,
This is matter for 2 weeks.
highly obliged.
Item number 4.
Yes, Mr. Devon.
It will take some time.
Yes, it'll take some time. So you start.
So, Lordship, the last occasion, this last hearing, that I have given this. What is the differences between it? That's Samuel Raja has been appointed, how it is appointed, and what is the illegality? Last question, Your Lordship, I argued what is my bona fide
Yes, because that is only with regard to your, demand for
and
area
demand
salary.
and area salary, and this how I am paying before the National Board for my salary.
Yes.
And as regard this, after my appointment, then another teacher was appointed, Samuel Raja.
Yes.
How he is appointed and what is the illegality thereof? And even if he has been appointed, but it was the appointment by the managing committee. On this appointment,
You have challenged his appointment in your.
no, Your Lordship.
Then?
Your Lordship, here, why it is not required? Because he was appointed for a particular period by the managing committee, not following the due process of law.
Was he appointed in your stead?
Not in my place. So it should, if it is in my place, then it should be advertisement.
Exactly. So
There should be. So
what
there.
is your grievance against him then?
So Your Lordship, here as because they are main this objection is my payment of salary. This Mr. Rajak is appointed, and due to this I am not entitled for the salary. This is the one of the grievance of the managing committee. So here, Your Lordship, I have given even the Rajak who has been appointed by the managing committee. That point of managing committee also not there, and it is on record. I have produced. So even if I even didn't challenge this Rajak order, then also it is not having an effect in my petition. So here another aspect of the matter, Your Lordship, here I want to place before this report. Your Lordship, the inspection report, the page 11, Your Lordship.
Where is it?
Page 11 of my compilation, Your Lordship. So in report is the 9 and 11 is the type copy.
Just this one.
Your Lordship, in page 11
Yes,
is the
paragraph.
type copy. So we'll go to the first paragraph, Your Lordship.
Just a moment. Page 11 of your compilation.
Yes, Your Lordship, type copy. A main report is signed copy is this page 9, but it is not readable. So I have given the type copy. It will be clear about this.
Page 11. Yes. So this is the letter dated 10th May.
10th May. So you will see here, if I read the paragraph, it will be better, you will see.
Yes.
This that's this is the report of the inspector school.
Yes.
JPK Marak. That's Sri Imam Abdullah BSc Rual was appointed as science teacher of Heritage High School by the then secretary Sri A. Along by appointment letter number such and such as per resolution 1 taken in the meeting of the committee held on 7/8/1994. Copy which is along with the copy of the appointment letter enclosed and the appointment was approved by the inspector school Tura by number such and such. Sri Imam Alam Abdullah joined in the school in 3/10/1994. Copy enclosed and proposal for science grant was moved in his name in accordance and draft was sanctioned in his name from 3/10/94 to 28/2/1995. But after some times, on the pretext of Sri M. A. Abdullah is an outsider, the managing committee has decided to appoint one local person, Sri Samuel Raja, BSc Rural, and decided to place Sri Amarudha as an additional teacher. So, Your Lordship, here, if even this managing committee has taken the decision, what is the approval from the government? No approval, Your Lordship.
Yes.
And thus, the secretary of the school was issued an appointment letter to Samuel Raja. Sri Samuel Raja joined in the school on 11 August 1995. So, appointment of Samuel Raja has come 11 August 1995. But he has served the school only for 1.5 years till 1/3/1997. Next line is most important. Says, Science grant also was sanctioned in the name for the period from 1/3/95 to 28 to 1996 and 1/3/96 to 28 to 1997. Your Lordship, if the person has been appointed in 11th August 1995, how the even managing committee referred the name of the persons again even prior to this period? How it is possible? So how this managing committee, they are manipulating the document, Your Lordship, as they wish. So in 1/3/1995, Samuel Raja even didn't born. He didn't see the day of flight. How this managing committee taken the money, Your Lordship?
Yes.
So from beginning, Your Lordship, this happens to the petitioner. He has been deprived. Whatsoever salary they have given to him, he was accepting on good faith, and all this animality was not known to him. And all these animalities come to some time, they are raising some objections and others, and that they are settling by themselves. And after that, so when this matter has come to the extent, he is not getting salary, he is properly, and he makes some complaint. And out of this complaint, again inquiry took place. And this was the inquiry took place by them. When I am saying this, I am not getting salary. After this school has contacted me, and it was in 2000. So when 2000 inspector school went there, then also they find that in between they had done some wrong by the managing committee. But still that point of time, I am the teacher of the school. Then after this it is given here, and the same has been released and paid to him. Accordingly, the termination order was served to Sri Imam Abdullah. He refused to accept the termination and thus remained in the school, and he did this. And in the meantime, the terms of the managing committee were expired, and Sri A. Islam also no longer the secretary of the school, and by this time Sri S. Raja also resigned. So again the proposal for sunrise in the name of Abdullah was moved, and accordingly grant was sanctioned in his name for the period 1/3/1982, 28 this 1992 and 1999. So again they have taken. So Your Lordship, when I refuse this, I should be terminated by this order, verbal order. So I will not be accepting. So after that they continue.
Oh, it was a verbal order.
Verbal order. Accordingly, the inquiry report submitted by the district science supervisor Sri Amabullah has been doing his job regularly, and he has been allotted classes by the headmaster of session 1999. So Sri Imam Abdullah is the continuing his service as science teacher till today, and he has been receiving his salary up to November 1999. But sanction for the period 1/12/1999 to 2000 could not be drawn by the secretary of the managing committee, and it was lapsed due to the inner differences between the secretary and science teacher. So the allegation of misappropriation of science grant does not arise as per complaint. It learns that some interested person carried a political motivations about the existing science teacher to replace him by another candidate. As such, one additional science teacher also appointed by the present secretary to the school and pays salary to the new teacher out of the present science grant, which is not approved by the undersigned. So here in 2000, you will be saying that science grant were given in the name of the petitioner, but they have given to others, and there is no sanction. It is clear in this report, you will see. However, Sri Imam Abdullah is still in the school, and deserve to get the salary of science teacher sanctioned in his name. So, Your Lordship, here in this inspector report was saying that whatsoever salary was granted for the school, it is given in the name of the petitioner. And managing committee is saying it is coming to the managing committee and managing committee is paying the salary. It is not in the name. And I have given the notifications to even the orders in which stands in the name of the petitioner. Regarding the formation of managing committee for this school, this in between again there is come up the next paragraph. Regarding the formation of managing committee of holding school, it is office has repeatedly asked the headmaster of the school to convene the public meeting to elect a new member of the managing committee, but due to many factions and groups in the area section, selections of the member of the managing committee could not be done. Even the public meetings were held for 2 or 3 times. Therefore, the managing committee school was taken over by the inspector school. So, Your Lordship, even subsequently when there was difference in the managing committee, then inspector school is taken into consideration. And when the inspector school taken into consideration in the matter, that point of inspector school make payment to me directly. So, I got the payment.
Since when?
So, Your Lordship, I am coming about it, Your Lordship, the payment and others. I am giving in my synopsis chronology, but
Okay.
I am coming about it. What is the case about? Just to explain, Your Lordship. And after this, I will be going my compulsion serially also. It will be all right. So here, Your Lordship, another aspect of the matter. If we come to this page 13 of my compilation, Your Lordship.
Yes.
This is the one of the page number internal page 26 of the affidavit notice filed by the managing committee.
13, you're referring to what?
Page number 13
Yes.
of my this compilation.
Yes.
This is the internal page of 26 of affidavit notice filed by the managing committee.
Nothing is here.
So
Yes.
here you will see
Page 13.
page 13.
This is only,
The tabular chart.
yes, this is 9, 10, 11 and 12. Serial number 9, 10, 11, 12.
No, you will see this is the chart. You will see page 13.
It's not 13.
Let me see. You will see internal page 22.
Page 22.
Page 13. You will see this mark.
Here, it's not here. In this compilation, you have referred just now to page 11. Just a moment.
13. You will see.
Guinea. Pagination is all wrong.
Let me see. You will see just. In page 2, you will see I have given admittedly managing committee stated in affidavit opposition in paragraph
Just a moment.
8, page 26, in tabular form, serial number B.
B.
You will see,
Table B.
you will see here in table B is here. I am referring in my things, but I will be referring as a whole. So page 26 it is given. You will see, for the kind satisfaction of the Honorable Court, the following is the statement showing the particular payment made to the deed petitioner as per entitlement as below. So this is the satisfaction given
Yes.
for the entitlement. So you see here it is given 1397 to 28 to 1998. Additional science teacher paid the registry honorable High Court. And then after that given, you receive 1/3/1998 to 31/3/1998. His service was terminated as additional science teacher with effect from 31/3/1998.
Yes.
Then if you come to the next, you will receive 1/3/1998. You will receive here date is so crucial. He was terminated as additional science teacher with effect from 31/3/1998.
Yes.
Here in the next you will see 1/3/1998 to 31/11/1999. For this period they are saying he drew the salary of the science teacher from the inspector school misleading the state authority. School had no MC during this period. So you will see 1/3/1998 to 31/11/1999. The managing committee admittedly stated there was no managing committee. So had it been so, if there is no managing committee, how here another termination letters come up on 31/3/1998? They themselves there is no managing committee.
Where is this termination letter dated?
So managing committee knows what the termination letters. Managing committee knows termination letter.
No, it must have been issued.
So I don't have.
You don't have the. How do you know that you're
So
terminated?
they are claiming now. They are coming now. So I am coming. Because in 1995 they are shown terminated. Again 1998 they are saying terminated. So then again 2002 terminated, which I have challenged. I am coming on it, you will receive again because I started from there 1904 2002. Out of these court cases come up, then court has passed the order, then I am in service. Otherwise I couldn't have been in the service. So here also they have some terminated. So if it is terminated, you will see admitted in the next paragraph they are saying 1/3/1998 to 31/11/1999.
Yes.
There is no managing committee.
Yes.
You will see if I come in the next paragraph, you will see.
Yes, just a moment. Yes. So
You will see here now. Next C.
see.
1/12/1990 to 29 to 2000. For this particular period, you will see Srimati Isma Tara Rahman, regular science teacher with effect from 7/11/99, so paid to her and present deed petitioner was no longer the additional science teacher of the school. So this is the claim of the managing committee. Here you receive, if I take into consideration paragraph B, true, then how this managing committee on 17/11/1999, when there was no managing committee, can appoint even the Ismatara Rahman, who is the respondent of 12 here. Here nothing is there. They have procedure they followed by the government. No sanction, no advertisement, nothing. They have appointed the Ismatara Rahman. Even if you consider paragraph B, page 26 of the affidavit of the managing committee, admittedly in base saying that there is no managing committee during this period. So when this managing committee was not there up to 30/11/1999, then 17/11/1999, how they could have appointed the Ismatara Rahman? So this is the false affidavit given. The false statement is given before this honorable court.
Yes.
So now their claim is there, in place of me, they even after Samuel Reza, Ismatar Rahman is there. So this is their claim. Managing committee claim and state is supporting. So here, Your Lordship, if I come to the page number 96, Your Lordship, it will be how this managing committee there. Let me see, Your Lordship. Page number 96.
Yes.
Director of Higher and Technical Education Meghalaya Institute, dated 29 June 2004.
Yes.
This is much after the termination was issued.
Yes.
So here it is given to the inspector school. Subject WPC number 3107-2003, Srimati Ismatar Rahman versus State of Meghalaya and others. This is the case reference given. Ismatar Rahman filed one case, and out of this case, some order was there, and out of this order has come up.
Yes.
This letter number such and such is given. In inviting the reference to the above, it appears that Srimati Ismatar Rahman has been appointed by the concerned managing committee as science teacher till date in Holiday on Saracen School. If such is the case, Elusive, if such is the case, you are requested to take up the matter with the managing committee for payment of her salary in time. Further, the managing committee may be also be informed that they may be appoint additional teacher on their own expenses, as the government has sanctioned one post of science teacher only in all the edu grant in the school, which is the government policy. So they are saying government policy is there one post, and Ismatara is not there in the record. So up to 2004, June 2004, you will see, name of the Ismatara Rahman is not there in the government record. And managing committee is saying she is the teacher, science teacher. So even, you will see, out of this is the government record, you will see, out of court proceeding, then government director of higher education, you will see, it is issued. So we can believe that this is correct. Now here you will see, as per this statement, the Ismatar Rahman science teacher with effect 17/11/99. I am coming again this page 13 to internal page of 26 of this affidavit. Because of it, another aspect of the matter you will see here. Ismatar Rahman science teacher 7/11/19. So paid to her, and the present witness has no longer the additional science teacher of the school. So saying when this Ismatara has been appointed, then even additional science teacher who was I was having, they are saying this is also not there. Yes, to me. This page, internal page 26, is tabular form, leadership. Earlier referred page 13. This tabular form. Paragraph 8 of the affidavit of opposition.
Paragraph 8.
Paragraph 8, this page internet page 26 of the edition affidavit of opposition, and tabular form C. Tabular form C.
This one.
Already referred, but some other points is there. That's why you will see.
Just a moment. This is the affidavit of opposition of
Managing committee.
managing committee is respondent number
9, 10, and 11.
Is that paragraph 8?
Paragraph 8. Internal page 26, Your Lordship.
This is the same one.
Same matters, same paragraph, Your Lordship. Earlier I referred this one, 1711-1999. Again, there are some points to be discussed, Your Lordship. That's why I am referring again. Just I have referred this matter, Your Lordship.
Yes.
Because I am countering this one, this Ismat al-Rahman regular science teacher, which from 1711-99. Already I discussed that even 1711-99, as per admission by the managing committee, there was no managing committee.
Yes.
So here, Your Lordship, why I am referring again, maybe confused, Your Lordship, just to clarify. Here clearly given that so paid to her and present deputy was no longer the additional science teacher of the school. So paid to her. That means, Your Lordship, for 17/11/1999 onward, the sanction is coming in the name of Ismat al-Rahman. According to their admission, Your Lordship. Here, if I come to this page 48 of my this compilation, Your Lordship,
Yes.
Your Lordship, you kindly load it. Page 48, this is the tabular form given, and salary for the period. Basic plus D8 is given. You receive 1/12/99 to 29/2/2000.
Yes.
Then in the next page, you will see 49, serial number 36.
Yes.
This seat is given Holydegon's Higher Secondary School. Then you will see papers DA total amount 4375. Then the period has come up 1/12/19 to 29/2/2000. Then amount is given 13,125. Then is the name Sri I.MD.A. Abdullah. So you will see here in Major is saying that for the particular period 1/12/1999 to 29/2/2000 was paid to the Ismat al-Rahman.
Yes.
How it was possible, you will see.
So you have received this?
So you will see I am having this.
No, as far as this, see, this sanction is.
I am having.
As far as this sanction is concerned.
As far as the sanction, I didn't receive, so that's why I am before this report. Some I have received. Out of the sanction, time to time, I have given this tabular form in my synopsis. Sometimes I receive, sometimes I receive. So when I receive, then I have given, I receive. So why I am tabular form, I am saying at the moment, which is so bring before this report, because my contention is there was a limited here. Only for this page number 3, you will see the tabular form they have given. The salary, whatever area they have shown to me, I am entitled, whether it is correct or not. This is my case. So for the particular purpose, you will see. I have challenged this one, annexed this one, you will see they have given my area of salary, claiming to be 37,500, I am entitled. So here I am showing, you will see all these methods before this code. Due to this, you will see, I am stating here, whatever they are saying here, it is not correct position. This is not the correct position. Even here, if I admit that this is the correct position, then I will be compelled to return to the government money whatever I have received. Sometimes managing they have given through the headmaster. Sometimes inspector school given some money. So this is not in my claim. Whatever I got, I didn't claim. So here in this chart, you will see totally false statement is given, just to deprive me from my regime dues.
Where is the chart? This.
So you will see here.
Where is the chart?
You will see in my compilation page number 3, which was challenged before this annual code.
Yes. You have referred to this. Earlier you have referred to that.
I have referred. So, Your Lordship, I am again coming due to this because they are giving the period. Suppose they are given 1/3/1997 28 to 1998. They have given me 1,500. Then after that, they say 1/3/1998 to 31/3/1998, 1,500. Then after that, there's 1/4/98 to 28 to 2009. Then it is given, Your Lordship, this it is a after retrenchment from the service of additional sciences, no formal appointment issued to him by the MC and approved by the IS as available from the record. So they are giving the clean sheet that's for this particular period. Even I am not the teacher, so I cannot have any claim about it. And subsequently, it is given 1/3/2009 to 31/5/2009, 6,000 per month. I should get one sanction post transfer from the such and such security school in compliance with the Honorable High Court order dated such and such. And accordingly, M. Abdullah was already accommodated in the newly transferred post, which was from 1/3/2009. So this is the here whatsoever they have given, this I am entitled for it. So what is my entitlement? Due to this, Your Lordship, it is required to go all these materials because it is most important in my case. That's why I am taking some time. Otherwise, Your Lordship, simply I could have said this is the salary entitlement of mine and this is the order, and how this order has come up and how they have manipulated. Here, Your Lordship, at the moment, because respondent number 12 also as Sumoto has come in my petition to be a party, and subsequently some order was there, and the state government also whatsoever they have taken the step stand in the first litigation, they are changing their stand here in the writ petition and supporting this illegal action of the managing committee. Even here in this affidavit, they have given the false affidavit. Whatsoever affidavit given earlier and filed the writ appeal, they are just ignoring all. So due to this, Your Lordship, I have to take some little bit time about it because it is most important to me to just explain how this situation has come up. How this situation has come, again and again I have to come before this Honorable Court. Because they have stated that already matters is resolved and it is res judicata. Why it is res judicata? What is the challenge before this Honorable Court at the moment by me? Whether I am challenging others litigation which were already solved. This is the one question. So here in this case, they are saying the first instance when they filed the even written argument, they are saying that when I didn't challenge the order of the Samuel Raja, I don't have any stand in the matters of this writ petition subsequently. My submission is here, Your Lordship, out of it. Samuel Rajak was appointed by the managing committee. They didn't follow the due process of law. And if the managing committee is appointed to anybody for their own benefit, I should not have any grievance. And I have been appointed by the government in a government post, duly sanctioned post, duly followed the procedure, and I have been selected and then give the appointment. And here, if even so, taken into consideration, the managing committee has taken the decision to put me the additional teacher, they don't have any right. Because, Your Lordship, I have been appointed following the due procedure, and without due procedure, they cannot appoint anybody and they cannot replace me.
So basically, that is your contention.
So Your Lordship, this is the contention, and another thing is that there is no policy in the government that if the person is being outsider, he will not be in a position to work in the service.
That is a different thing.
This is different. So, Your Lordship, I am not coming because they have raised this objection, so I should give the reply. So, my reply is to that extent of this. And here, Your Lordship, when I was asking for my salary, and after that what happened, how this terminator's order has come in 2002. This also I have to explain because of it, Your Lordship, how this problem has come up. When I am not getting my salary, then I have given the complaint. One inspection took place in 2000. Again in 2002, I have made the complaint, I am not getting my salary. So when I make the complaint, then after that, director has given the order to pay to me straightway my salary. So when this order has come up, it was come on 18, and 19 itself, they terminate me.
Okay.
What is the malafide, Your Lordship? And then after that, all the sanction is in my name. They are not in a position to achieve their selfish gain. subsequently might have again, due to this reason, respondent of 12 has been terminated. And both of us, we are before this honorable court. So when this termination is already caused by this honorable court, so Your Lordship, if this order passed even 1995
Yes.
and 1998, whatsoever thereof, all merged. So there is no need even harping on the same matters. And if you go to this termination order 19/4/2002, clearly written, as per resolution of dated 19/3 of 1995. So if it is so, Your Lordship, how this managing committee again can say in my writ petition when I am coming only for my dues to clear? And I am not saying this, I have served this only for this. I am saying I have served this with the school since beginning, and sanction is given by the government in my name. And what is stand in my name to give up to this much? I am not asking any more, or I am not asking any exorbitant amount. So this is the case of mine, Your Lordship. There is no essay this, though I have given some matters how this managing committee was not, because they are giving the affidavit. And I feel that it is required to bring notice of this honorable court how this managing committee acted upon.
Yes. So who's you done?
Yes,
Finish.
some more will be required. Your Lordship.
Managing committee who's you?
Managing committee say,
Your Lordship is on the way. He got stuck in traffic. So
Your
he is on his way. I am for the respondent number
Your
12.
Lordship,
His state is
I am
also
more
there.
is required, Your Lordship, because some more things is required, because when I got the salary, how I got it, and how they given this also
Yes,
to
please, please continue.
So here, Your Lordship, another aspect of the matter. Now another aspect of the matter, Your Lordship, after the writ petition was disposed of, and then
Repetition.
writ petition in the first instance after challenging the order of 19/4/2002.
You have challenged.
I have challenged this order, and after this, High Court has passed the order, and then when this petitioner, even respondent number 12, was considered, that point of time, it is given one post to be created for the said school, extra post, and then matter could be solved amicably. So thereafter, state went to the division bench and stated this, I am the sanctioned teacher. So then after the division bench is considered to sympathetically, then post was created. So in the meantime, Your Lordship, when I was not getting my salary, even lots of problem was there, then I filed the contempt petition. So in the contempt petition, when this disposed of in my contempt petition, then it is specifically stated in this order, Your Lordship, in page 128.
128 of your compilation.
Compilation. In CP number 9, SS of 2009. I am not burdening this order of this High Court, Your Lordship. I am just only one paragraph.
Yes.
So, Your Lordship, the order to be complied with contempt petition is directed, given in para 7 of the order dated 28/3/2006.
Yes.
Have you got it, Your Lordship?
Yes, yes.
Passed by this court in WPC number 185 SS of 2002. So this is the writ petition filed by the respondent number 12. So in this, when disposing this contempt petition, it is specifically written that as per direction given, para 7 of this order dated 28/3/2006 passed by this court in WC number. As per direction contained in para 7, the aforesaid judgment and order is to sanction a second post of science teacher in the school in question purpose of the committee of the petitioner. So in 185, the respondent number 12 was the petitioner, and it has been accommodated to her, and accordingly when this inference was given, then contempt was disposed of. There's nothing is surviving here in this contempt petition. So you will see when this contempt petition was disposed of, and after that, when they're supposed to release my salary, that point of that started the all nefarious scheme. So subsequently, I compelled to file writ petition so that I should be paid the salary as per my entitlement.
So when this additional post was created,
additional post was created, you will see,
to accommodate the respondent 12.
Respondent 12. So how it is even you will see considered, I'll be coming on it. It is clear from this here you will see. You will see here in my compilation you will see the page 148 onward you will see.
One 48.
46. 147 onward it will be better you will see. This is the order.
Not clear. Where's the type copy of this?
This one type copy I don't have, you see.
This is page 147.
147.
Yes, what does it say?
It is the order is the first when this post has been transferred, and amount was given for 3 months 15,000. Page 148.
Not so clear, Mr.
1/3/2009 to 31/5/2009. 15,000.
Yes, but what does it say? For what? For what purpose?
So you will see it is for the purpose of salary of the city school. Then you will see in the next order 150.
Yes, then page.
Then you will see next page 150.
Yes.
So 150 you will see here in this given. 152 is the annexure of this order. It is given holiday on certain school, amount per month 6,000, 1/6/2009 to 31/8/2009, and less amount sanctioned by letter 3/6/2008 grant 3,000. And name of the science teacher Srimati Ismatara Rahman.
Yes.
So you will see here 148 what is the sanction given, and subsequently sanction is given additional grant. So this justifying that post was created and this amount has been paid to her. Then you will see next you will see next is the page 155.
Yes.
Then this is the receipt this of received this salary 1392 31/8/2009. Together amount to be 36,000. and subsequently it is the acknowledgement. Next, you will receive 158, page number 158.
Yes.
You receive in 158. This is the statement of salary in tabular form.
Yes.
So you receive here
Yes.
serial number 96. You receive
Yes.
Holiday Gone Secondary School. Amount per month 6,000. Period 1/9/2010 to 31/12/2010. Then in the right side you will see name of the teacher.
Yes.
Number 1, Sri Imam MD Abul Alam Abdullah. And second, number 2 you will see Srimati Ismat Al Rahman. And after that is given the star mark. In the right side of the name,
Yes.
it is given 1 post is personal and will be till retirement or resignation of the petitioner. So you will see this statement Director of School Education issued. So this clearly establishes, you will see, if this even new posting transferred by virtue of the order of this Honorable Court, and it is in favor of the Ismat Al Rahman. So this is also the government record you will receive, and I have given this, but there is no challenge, and state also not claiming this again because it is given by the state. So here, if even managing committee taking the stand, this newly post has been transferred and they have agreed to me in this post. It is totally suppression of material fact, and this is the false statement before this Honorable Court.
Yes.
Here now, Your Lordship, my prayer was only for limited to the extent of non-payment of arrear of salary due to me. So here, Your Lordship, when this managing committee is given the chart of this amount is payable by the managing committee, they have given the wrong information before this Honorable Court, and they suppress the whole material aspect. And this is also one of kind of misrepresentation before this Honorable Court by way of compliance of the order passed by the Honorable Court, and to save from the proceeding for contempt, out of which this amount was deposited. As because you will see here, this 1/3/1998 to 28/2/1999. Admittedly, Your Lordship, in my petition also I have stated that I got the salary 4,250 rupees.
Yes.
Whereas managing committee is saying here, Your Lordship, I was entitled for the salary 1,500 and they are giving. Assuming, Your Lordship, I am entitled for it and I got it. I ignore my things. If I admit this one, and if any inspection took place, and if I get the salary, then I am liable for payment of this rest of the amount you receive for the particular month. And if I admit this, only 1 month I was entitled and I got for the year, then whole of the amount I have to return. Should I accept this statement, you receive? First of all, question will come up, should I accept it knowingly? Definitely not. So due to this, I refuse to accept this amount of 37,500 because it is completely illegal.
Yes.
Not only suppression, but completely illegal. They are not coming before this legally. And then 1492 28 to 2009, you will see they are saying no record. You will see I am showing here record in my compilation. How this even managing committee they can say that there is no record.
What was the period just now you said?
They are saying this 1498 to 28 to 2009. There is no record.
1992.
1998
98
to 23 to 2009. They are saying there is no record available.
MC says no record.
This is the
no record because there was no managing committee at this point of time.
So Elusive, I'm coming this how they are saying this there is no record, whether record is there or not. This I'm just giving you.
Okay.
Elusive, kindly come to this page 30 of my compilation. Elusive.
130.
Only 30.
Yes.
This is the acquittance rule which I have given.
Yes.
And in this Elusive, I got the salary for 1699 to 31st 8 1999. And it is as per the government censure.
$1999.
1999 to 31st 8 1999. It was paid to me on 5/10/1999. Then another is the same Elusive.
In their affidavit, they said that there is no record for this period.
Yes, Elusive.
Which part of the affidavit?
So Elusive, this is the statement they have given when they are giving me salary.
The one you had referred to just now.
So Elusive, this is the challenge by me. This is the record challenged by me because they have given before this honorable court. They have given this one before this honorable court in compliance of the proceeding before this honorable court in contempt. So Elusive, another page 41 Elusive. One 3/99 to 30/11/99. It is given
page
41. Page 41 in my compulsion. This is the period for which the salary is paid 1/9/99 to 30/11/1999. And this salary was paid on 13/8/2000.
Yes.
Leadership, I just stated on this is the page 3 of my compilation, and this is the type copy. This is the next copy, type copy, leadership. It will be metted. It is clearly written when they have given the amount of rupees 37,500. So it is clearly written here. After retrenchment from the service of the additional solicitor, no formal appointment issued to him by the MC and approved by the Tura as available from the record. So here they are clearly stated that they are not having any record.
Yes.
So you will see here when I got the payment, I have shown here that how I got the payment, and subsequently you will see when this matter has come that I am not getting the salary and complaint was there, and subsequently it is come up that they terminate me by the order of the managing committee 19/4/2002, which was challenged before this honorable court, and subsequently this contempt and others matters has come up. So this also I have explained here, you will see.
Yes.
I just coming. Just coming here. You receive, may I refer this page number 69, you receive. 69. You will see here this in the April 2002, it may be you receive 17th April or something you receive. So this is the order issued by the Deputy Director Higher Education. Renewal of grant in aid in the maintenance of science grant in teacher education school, secondary school. With reference to the subject cited above, I am to state that the grant for the science teacher of Holydigans Secondary School has been released with effect from 1/3/2001 to 28/2/2002 in the name of the science teacher Imam MD AA Abdullah, copy enclosed, with the instruction that the inspector school Tura will disburse the science grant directly to the hand of the Imam MD Abdullah, science teacher, and not through the secretary of the school. So you will see, as because secretary managing committee they are not paying this salary to me, so particularly for the period 1/2/2002 and 28/2/2002, it was directed to the inspector to pay to the petitioner. So you will see the order of this government for the particular period, you will see it is the page number 64.
64.
64. This is the order of the government.
Yes.
And 65 is the period for which 1/1/2002 to 22/2002. You will receive. Then serial number 43 is the name of the petitioner. Then you will receive page number 71.
Yes.
Matter relating to the managing committee of the Holy Regans Government Higher Secondary School. On the subject matter, I am to state that complaint have been received by the undersigned that the managing committee of Holy Regans School has been constituted by the memo number such and such January 2002 for the period 18/1/2002 to 17/1/2005 without holding any general meeting, but on having been misled by the headmaster of the school. The signatory to the complaint includes K. Khan, President, and the Holy Regans School Deficit Upper Primary School, the headman, and another 80 persons. Copy of the complaint enclosed. In the complaint, it was further added that the sanction this grant to the MD Imam Abdullah was allowed to be done by the secretary to the new managing committee, which was unpaid to the teacher and was thus misutilized. Under the circumstances, I am to direct to you to make an inquiry on whether the general meeting has actually been held in free and fair atmosphere for the election of the office bearer, pending submission of this report and approval by the undersigned. The managing committee constituted by above letter dated 18 January 2002 should be kept under suspension. Please state this as most immediate. So there was a complaint, and in this complaint is given that I was not being paid the salary.
Yes.
So you will see, after this letter has been issued on 18th April, you will see, on the very next day, you will see that my termination has come. So this is the termination it is given. I will read again, you will see, for this. Your service are found no longer continuing in this school since after your termination on 15/3/1985. Sam 72. Next.
Yes.
You are therefore asked not to attend the school any longer, violation which is dealt severally. So you will see how this my termination has come fast and how it is happened. So just to explain this situation, you will see how it is happened. I have taken little bit time with this honorable court because it was required to me to go in details in the matters. So here you will see,
Yes.
had it been terminated and it accepted in 15/3/1995, then there was no cause to even issue the termination on 19/4/2002. And this order already has been set aside by this honorable court. So when
this 15/3/1995.
You will see when
This
19/4
order 15/3/1995 was set aside.
19/4/2002 order.
Oh, this
19/4. So when this 19/4/2002 has come, so earlier if any order passed by the school authority, then all are infructuous.
Okay.
Because Your Lordship, if I have been terminated several times, then there is no ground to terminate to be 19.4.
Where is the reference to this order being set aside?
This is the order which is already I have mentioned, Your Lordship, order WPC number
Just
168 of 2002, Your
Just
Lordship.
remind again. Order dated
Order dated 28/3/2006.
2006 in
This in WPC number 168 of 2002. It is page number 97 in my compilation.
yes.
So here in this writ petition, Your Lordship,
Yes.
the petitioner herein, in this petition, basically he didn't challenge any matters as regard to the bona fide or maintainability of the any grievances by the respondent of 12, or not the petitioner has raised any grievance against the respondent number 12. Because, Your Lordship, if I go my prayer, Your Lordship, nowhere I have stated that I am having any grievance against the respondent number 12. And it is required, Your Lordship, because in my petition, they are the respondent of 12. So, question will come up when then I meet the party. Because they are the common judgment,
Yes.
and subsequently when another proceeding, I ask for this, my area of salary, then petitioner, this respondent 12, herself came in my petition, make the necessary party. So subsequent proceeding, in essence to her, if I make the petition, then it will be misgender parties. Because already she is in my petition. What is her grievance? Nothing is specified. And what is the grievance against me? Nothing is specified. So this is the clear out of the judgment order. That her claim is different, my claim is different. So here you see, I have given this only the my contention only this much. This admit the petition, issue the rule.
Which
This page number 20 of my this petition, writ petition. This is the prayer.
Yes.
So I am limited to the prayer because you see what's the process plus all this I have already. But what's the prayer before this court? Because I have argued about the Lucas Tendi of mine. Where sir I am appointed teacher regularly not, and where the sanction post or not. Everything I have argued before this court, because court has just raised the question about my bona fide. So to testify the test of bona fide, you will see I went to my appointment, how appointment moved, and after this whatsoever other action taken. But it was not necessary in this case. But it was when objection was raised by way of affidavit. So that's why I just given the clarification of mine. And if any other clarification required, you will say I will give. But I'm trying to sum up the matters, because otherwise it will be another more and more. So here, see, now I'm just before summing up the matters. What's the pair of mine before this honorable court? I'm just putting this on pair of mine, because I have argued so many. You see, I'm going to one place to another, again come in the stand, again I will just move other place. So it will situated. So whatsoever exactly petitioner before to you, see. So this is the prayer. So prayer is like that, you see, that to issue the notice or SMS to why the writ of bendabas and or any other writ should not be issued upon directing the respondent to release the salary as per government sanction in favor of the petitioner forthwith by draft or account paycheck along with interest 12% from the date of disbursement of government fund to the school.
Yes.
So you will say my first prayer is there that I am praying before this honorable court to make the arrear salary of mine as per government sanction.
Yes.
Then Father be pleased to quash the letter dated such and such dated 33/2015. So you receive in my compilation and page number 3 is the annexure and 1 and 2 is the letter.
Yes.
So I have prayed before this court to quash the said letter.
Yes.
Was the letter dated such and such issued by the Secretary of the Horizon Government High School, which is not in conflict with the Honorable High Court order, as well as government order passed from time to time. I am saying, Your Lordship, this court has passed the order as per my entertainment. And as per entertainment comes on the basis of government order passed from time to time. So I am telling you here that whatsoever this area of salary has been paid to me, so this is not in conflict with the order of the government. So that's why to quash the letter dated 33/2015 and awarding the cost to the respondent for misreading this honorable court. And then another prayer is there, Your Lordship. It is up to the honorable court. Your Lordship, I was having earlier pay scale with DA, but after that government has given to me consolidated amount. So earlier it was my position was there when I was appointed that there's a pay and DA, and now depend consolidated. So I am praying that my pay and DA whatsoever earlier it was there, it should restore. So this is the prayer before to me. So in the prayer I didn't say anything that what is the about the Ismatara Rahman and others. I am saying just to make payment to me on the basis of this government sanction, only this much. So here you will see so you will see here another aspect of matters I just made to this honorable court. You will see this may come up when I refer the writ petition 168 of 2002. Thereafter, Managing Committee has filed one writ petition, and in this writ petition, they challenge that I am the additional teacher. So subsequently, Your Lordship, I went to this division bench, and division bench it is already given that my position science teacher should continue, not as a additional teacher. This order also there. I have given a compulsion, but it is not coming because I am not going for this my because I am limited to my because already when court has passed the order, so it is integram. So when this final order come up, all this order become merged with the final order of the writ petition, and it is given it will be subject to the outcome of the writ petition. So you see, Managing Committee has stated that in the court it has been declared. So subsequently the division bench it has been quashed and is given no, my position will be a science teacher, not additional science teacher. This also been decided. So this is also part of it. So I am not coming if required then I will.
Yes.
Because otherwise if I go you will see another length of argument will be there for particular purpose. So here after the summing up of this matter you will see that's in my compilation. Lastly I have given in page 12 you will see in my compilation this index page 12.
Yes.
So here you see it's 12 A, B and C I have given marking.
Yes. Was AB.
A, B and C I have given. You see it is 12 serial number 12 ABC. So 12, Your Lordship, I have given this one citation. It is unreported, but I have given the full citation. Ramchit Barma and other versus State of Uttar Pradesh. So this is the matter, Your Lordship, that if the person is served in the office, even in the interim order there, then he is entitled for salary for the period served. So this is court already as having this. So then after this I have given how this authorities passed the order and how much entitled according to me. So here Your Lordship, on 1/3/1997 to 28 to 1998, government center is not available with your petitioner. So I have given Your Lordship, I didn't mention any amount, though I am entitled, but I don't know what is the amount and what is the sanction order.
Okay.
Then after this I will 1/12/2099 to 29 to 2000. I am entitled for the amount. This is basic pay and DA. This 13,125. Then after this I have given 1/3/2001 to 31/8/2001 are not available to your petitioner, withdrawn by the managing committee, such and such.
Yes.
Then after this I am coming 13/9/2001 to 31/12/2001. This is 18,000. Then you receive here 1/1/2002 to 28/2/2002. This amount one there. Then after this you will receive in Roman 6 I have given this 1/3 with effect from 1/3/2002 such as sanction with the basic pay and DA and was paid by the administrative school, and 2/3 which drawn by the managing committee. So you receive here 1/3 it has been given, yes, and 2/3 is not been paid. Then I have given with effect one
salary, one third only given.
This 1/3 was given for one particular period. Yes, paragraph 12. Page number 12 is Indian page.
Yes.
Then 1/3/2005 to 28/2/2006. This is the amount of 55,500. Then page 3, Roman 9, with 1/3/2006 to 28/2/2009, 1,88,500. Then with from 1/3/2009 to 31/5 such and such, this 18,000. And total amount is coming whatever as per this available record with me, and this is coming 4,77,125. This is my entitlement. This is my case, Your Lordship. And the petitioner is praying before this honorable to make the error of payment of salary, as because they are not paying in time, so that's why they are asking for the interest.
Yes. So who's to?
Lordship, may it please your Lordship.
Mr. Chaudhary, what we can do? You will reply on the next date, tomorrow.
My reply tomorrow.
This has taken quite some time. There are.
It will be because I am to meet a number of points my friend has raised, all not based on fact. So it will take time for me. Minimum 1 hour or more it will require.
So tomorrow?
Yes, tomorrow.
What is your convenient date? You tell me.
Tomorrow, tomorrow, no? All right.
What? Mr. R. Depra, Letter Counsel for the Petitioner. The reply by the respondent will be given on the next date. This is matter tomorrow. Actually, the reply of the respondent will be given tomorrow. List accordingly.
Item number 5.
Your Lordship, I was supposed to file my written argument on the last day during the course of the day, but the written argument was prepared by my junior colleague after I gave her some instructions. After going through that, I found that there were certain documents which were not enclosed with, right from the inception of the writ petition. Because what had happened, Your Lordship, was this writ petition was filed as an unlisted motion before Justice S.R. Sen, and it was moved by Mr. K. Paul, Senior Advocate. So, on that basis, a stay was given. Because, Your Lordship, the impugned orders are dated 25/2016 and impugned notice dated 9/6/2017. Now, Your Lordship, the instant the petitioner number 2 had joined service in the year 2017 and had written a letter to the respondents number 2, 3, and 3, 4, and 5 to give him some time, as he had just been appointed as the managing director of the petitioner company, petitioner number 1.
Okay.
But he was not allowed. And, Your Lordship, the impugned notice of demand dated 9/6/2017 states, if I may be allowed to read, Your Lordship, page 46, Annexure 11, Your Lordship. Lordship, para 3, sub para A.
Yes.
You are informed that in the case of default, steps will be taken to realize the amount in accordance with the provisions of so and so and so. Subpara A. Attachment and sale of movable or immovable property of the establishment, or as the case may be, of the employer. And next page, Your Lordship, 47. B. Arrest of the employer and his detention in prison. That is why we had come forward before this honorable court via an unlisted motion, Your Lordship, to get a stay. But, Lordship, in the index itself, Your Lordship will find that from Annexure 3, which is the notice dated 25/3/2009, page 31 and 32, Your Lordship.
Yes.
Thereafter, Annexure 4 is dated 7/4/2009, page 33 and 34. Now, Your Lordship, thereafter, Annexure 5 is directly dated 10/6/2014. Annexure 5 is page 35 and 36, Your Lordship. It's directly dated 10/6/2014.
30.
Pardon, Your Lordship?
Annexure 6 page 37, isn't it?
Annexure 5, Your Lordship. 35, page 35. Type copy is page 36.
Yes, 10/6/2014.
Yes. Your Lordship, if Your Lordship goes from the index, it will be much easier. What I want to say is that from 2009, we were aggrieved by the notices, Annexure 3. Now, Annexure 4 is our reply, but we have gone directly to 10/6/2014, which is another notice by the respondents 3, 4, and 5. Now, in between, there's a lapse of 5 years from 2009 to 2014. There are certain documents, Your Lordship, which are very important and which will assist this Honorable Court to reach a reasonable and just finding. So, I humbly pray that I may be allowed to submit those documents before this Honorable Court.
Mr. Thawa, at this point of time,
I'm sorry, Your Lordship.
You should have realized it. This
Because, Lordship, first and foremost, this writ petition by itself was not prepared by me.
That doesn't matter. You see, you have taken over the brief.
Yes.
You must be well acquainted with the facts and circumstances of the case. You must have noticed all those, as you have noticed now.
That is
This matter was prepared in 2017.
Yes, yeah.
So at this point of time,
Lordship,
what useful purpose would it serve?
the only thing is because there are certain documents, Your Lordship, which are quite relevant.
You have to go back to back to square one then.
Lordship, it won't change the nature of this writ petition, nor will it affect the other the respondents. It is just that to bring on record. And thereafter, Your Lordship,
How will that help your case, Mr. Thawa? Tell me.
Because as of now, I will not be able to, even in my written argument, I will not be able to rely on those documents. Because as I said, on the last occasion, Your Lordship had given me the opportunity to file the written submissions during the course of the day. But before filing, I had just gone through and I found that some documents, relevant documents, were not there. Your Lordship, for the interest of justice, I pray that.
Lord, I have serious objections, sir. This is a 2017 matter. And my lord, they have filed their rejoinder. Affidavits were filed, rejoinder was filed. Nothing was ever brought on record.
Rejoinder was filed?
Yes, sir.
Rejoinder was filed, Your Lordship.
No, nothing was. This is a 2017 matter. My lord, it has not gone to the notice. My lord, it cannot be accepted at this point.
Lordship,
whatever materials are on record, let the...
It will not affect the writ petitions, because there are two writ petitions. It will not affect them, nor will it affect the respondents. And if they want to reply to that, they can, Your Lordship.
It doesn't affect anybody, then why should you bring it
by filing the documents.
Written submissions, everything has been filed. Hearing was concluded. It's not a case that these matters, these issues were raised during the hearing.
Your Lordship, in the interest of justice, because I am representing the petitioners, so of course there are lapses on my part also. I will not deny that fact. But while going through on the last date, Your Lordship, I found that it is quite essential that these documents will in fact assist this Honorable Court also to come to a reasonable and just finding.
Anyway, I'll give you the opportunity, but only once.
Yes, Your Lordship.
Thereafter, what you can do is file it, advance copy to the respondent, let them reply.
But the only problem is, then where he will include it? Is he going to include
No, it has to be by way of an additional affidavit.
Let him withdraw this writ petition, let him file.
Your Lordship, by withdrawing this writ petition, then we'll have to again file afresh. That will
The question is where
lengthen the thing more.
All of a sudden, certain documents are coming. Where? Is it in the rejoinder or how, man? How is it filing?
Which are not.
What you see, now what he has come is, out of the blue, he has just referred to certain documents which are, according to the material.
Because on several occasions they sought for time for written argument. Now this is a new...
No, Your Lordship, it's because we will file the documents by way of additional documents, Your Lordship. If your Lordship permits.
My serious objection may be recorded.
Mr. Thawa, you have not really demonstrated how those documents will help you. You have come against an order where certain directions were, issued against you.
Yes, Your Lordship. Penalties were imposed.
Penalty for which you are to pay if you don't comply.
Yes.
So what is to be determined here is whether you are an establishment which comes under the purview of the EPF Act, whether you have complied with your statutory duty, and if so, what will be the consequences, or whether you are not required to comply with such provisions or duties. That is the the simple
That is, of
question to be answered.
course, the gist of the matter. But the complication here, Your Lordship, is that the EPF has misled the petitioner company since the year 2009 into believing that they have the power to cancel the exemption granted to the petitioner company. And this has led into all sorts of trouble, Your Lordship. And the predecessor of the petitioner
Who
number
has issued
2.
the exemption is the government.
Yes, Your Lordship.
How can the EPF?
That is the problem which
That is what they
was
have done.
created. Yes, Your Lordship.
That is on record.
Yes, Your Lordship. It is on record.
Your Lordship, I don't know, but actually I don't have that record. And Miss P. Bhattacharya, my senior, she is out of town. I need to seek instruction from her.
It is on record, Your Lordship. In fact, the Annexure 3, Your Lordship,
Annexure 3,
page 31. Is the notice by the EPF, the respondent number 3, Your Lordship, to the petitioner number 2 to show cause why exemption under so and so and so should not be withdrawn. Now, Your Lordship, there are certain other documents also, such as Annexure 5, page 35. Page 36 is the typed copy, Your Lordship.
Justice. So this exemption under section 17, 1A,
Yes.
Is given by the EPF or by the government?
By the government, Your Lordship.
This letter is issued by the EPF.
No, the reference here to the said exemption,
The
section.
exemption was granted by the government. No doubt.
Then how can the EPF issue this kind of letter?
My lord,
Should not be withdrawn means.
my lord, to my understanding, my lord, the EPF does have certain powers.
But not
But
to
it is for
withdraw
them to
the
argue.
exemption.
It is for them to argue, but EPF does have power. There are certain provisions of this act.
No, but that seems strange, because how can they override the issuing authority?
Nevertheless,
Issuing of a show cause in this form means they are also competent to
my lord,
withdraw.
nevertheless, my lord, but that is not on the challenge here. My lord. My lord will kindly go through the prayer. There is no whisper about this.
This is where it started, Your Lordship. This is the way it started. That's why, Lordship, in the beginning I said that since the year 2009, it directly goes to 2014. And in between, there are no annexures annexed. So this was the beginning, Your Lordship, when this was the first notice that they sent. And this caused havoc because the petitioner company, the petitioner number 2 as well, the predecessor of the petitioner number 2, was made to believe that the EPF had the power to cancel the exemption granted to the petitioner company, and which led to a chaos in the company itself, Your Lordship.
Kindly go through that prayer. There is no whisper of hope. In fact, they have approached this honorable court for quashing the impugned orders dated 25/2016 and 9/6/2017.
Yes.
These are the two orders which is.
Those are the impugned orders, Your Lordship. But how it started,
Well, Mr. It may have started in this form, but the fact remains that if you at this point of time come and challenge the authority of the alleged authority of the
Your Lordship, during my oral submission, I had pointed all these points. But on that date, when Your Lordship had given me the opportunity to file the written argument during the course of the day, I found that certain documents were not annexed, which are quite vital, Your Lordship. Because the main beneficiaries of the EPF are the employees, and they are the ones who are suffering now, Your Lordship.
Suffering at your.
They are not getting anything, Your Lordship.
Yes, they are also not before this court.
Not before this honorable court.
But no, the EPF is,
They are supposed to look after them.
What the very concept behind this one, the exemption is there, but that amount of money which is otherwise meant for EPF will be invested into better investments. That is the whole criteria of the exemption. Now, if that criteria is not followed, then what happens? That is the case. So
But
that is
that-
exactly why these notices were issued by the Provident Fund.
Oh.
Because they are
for
not
not
utilized.
for not having utilized the amount which they allegedly have got as a result of the exemption.
Yes, because that money has to be invested in better investments, supposed to give better returns.
Okay.
That is the whole.
Which they have not done.
That is the whole issue.
The allegation is that we have not done, but Lordship, as I had stated, that I may kindly be allowed to file certain
So
documents.
those documents will prove that you have done it.
No, Your Lordship, it will show that how the EPF has created a lot of chaos in this.
That's beside the point. That's beside the point. The basic issue is since you have got the exemption.
Yes, Your Lordship.
On the ground that you are to utilize the amount for certain beneficial purposes vis-a-vis the employees, and you have not done so. Therefore, notice has come in that respect. So you are to answer to that. Whether you are entitled for the exemption, and whether after the exemption has been given to you, whether you have complied with what is required to be done. You have not done that.
Lordship, that is the reason why I'm again saying that those. Because Your Lordship, it'll just take one. Just to file the additional documents.
Reopening the whole issue again.
No, Your
Because
Lordship.
you have to file your counter then.
Yes, my lord. This will drag on for some more time then. That also, my lord, for written argument, they have sought several occasions. They were never objected, in fact.
That is the thing what I'm saying, that on the previous occasion Your Lordship had given me the opportunity to file during the course of the day, but while going through that I found that vital documents were not annexed. Your Lordship, if your Lordship just goes through the index from 2009, it goes directly to 2014, which is a lapse of 5 years. That means during that time there was no communication between the EPF and the petitioner company.
There may have been, but in my respectful submission, there was a conscious decision taken by the council that what is to be included, what is not to be included.
Now, the main beneficiaries are the.
If I'm not mistaken, my friend is there in this case right from the beginning. If I'm not mistaken, his wakalatnama will.
Yes, but it was moved initially as an unlisted motion
Beside the point.
by
Because
Mr.
of the
urgency of the
yes,
matter.
you could have.
And due to that, certain annexures were not annexed, Your Lordship.
That Mr. D. Thawa, Director Counsel for the petitioner, at this juncture has made a submission that due to inadvertence, petitioners were not able to produce before this court certain relevant documents which would strengthen their case and also which would assist the court in coming to a just decision in this matter. It is therefore prayed that such documents may be allowed to be produced by way of an additional affidavit. Mr. KP Versarji, Leonard GA, appearing for the state respondent, has strongly objected to the prayer made on the ground that this matter has travelled from the year 2017 till date, and the matter is fixed only for filing of written argument, the oral argument having been heard. Therefore, at this point of time, the bona fide of the petitioners is to be questioned. The prayer made may not be allowed. Submits the Leonard GA. No submission is has been advanced. You are not making any submission?
Your Lordship, I need to seek instruction from my senior regarding that. Even me, I have the objection.
This provident fund is a very important part.
They are the main. As for you, you are nothing.
But we are also there, no doubt, because we granted the exemption. But nevertheless,
just now my senior on this
will
told.
Also be important.
The counsel for the respondent to PF
3, 4, and 5.
3, 4, and 5 is not represented by the
2, 3, and 4.
2, 3, and 4 is not represented by the assigned counsel. 2, 3, and 4. Proxy appearance has been made by General Counsel Mr. who has submitted that he has no instruction in this regard. She will be coming tomorrow?
Yes, Your Honor.
Considering the gravity of the issue raised, it is deemed prudent to allow the said respondent 2, 3, and 4 to respond to the prayer made. Accordingly, as paid for by the parties, this is matter on
Today is 3rd Monday.
On 5th. Day after tomorrow. So, Mr. Awa, you prepare yourself. If you can convince the court, well and good.
Yes, sir.
In fact, if you have any authorities in that regard, do it.
Yes, sir.
At this point of time, you see the issue of delay and latches will come. Questions will come. All those things will,
I understand.
we have to consider. Fine.
Highly obliged.
Item number 6.
Please, this is the managing committee matters, my lord. If your lordship recall, the matter was heard at length, and my lord, after the arguments were concluded, my lord, the respondents prayed to file an additional affidavit, yes, my lord.
That
to bring on record the constitution.
That resolution, the constitution.
My lord.
Who has filed that constitution?
The managing committee, respondent number 4.
Private respondent. So what remains now?
My lord, here we were praying since the arguments are concluded, let the party will be at liberty to file a written submission, my lord. The points argued.
Well, no, it may be listed for written arguments.
How long?
A week's time, my lord.
I'll say for 2 weeks.
Parties, letter counsel, appearing for the parties, have submitted that the oral argument in this matter has been concluded. It is therefore prayed that written argument may be allowed to be filed. On preamble, the same is allowed. Let the written argument be filed within the next date fixed. This is matter after 2 weeks.
Item number 10.
My lord has passed. We have filed the rejoinder.
You have filed?
We have received it, lordship.
So we'll proceed for hearing?
Both the matters.
Mr. Arjal, counsel for the petitioner, has submitted that the rejoinder affidavit has been filed before this court and has therefore prayed that this matter may be heard finally. On preamble, seems allowed. This is matter after 2 weeks.
11 also, my lord.
Same order. 11 same order.
Item number 12.
Please, Your Lordship. Your Lordship, I pray for some accommodation, Your Lordship, in this matter. Mr. Nongri is engaged in a part-heard matter in quorum number 2, Your Lordship.
How long?
2 weeks, Your Lordship.
On pre-made by the petitioner, this is matter after 2 weeks.
Thank you, Judge.
Item number 13.
It is this matter pertains to the payment of the delay payment of the interest. The last occasion, one had asked for the written argument here in this case where the court had passed the matter had travelled up to the apex court. The question was raised by the respondent number 2, that is Megafed, that who was attributable regarding the delay that has been the occasion. Nevertheless, since it is the right, so far the payment of interest is concerned, that the Act itself provides, and this matter was right from the inception in the year 2004 when the petitions were made to retire on the basis of a golden handshake scheme, and thereafter, after that, the payment of gratuity ought to have been paid, but right from the controlling authority at that point of time. Initially they had allowed and subsequently disallowed. They said that we are not entitled to payment of gratuity. Then thereafter a writ petition was filed, challenge in the single bench, and the matter was the Honourable Court was pleased to pass necessary order IFNX, where direction was given for payment of gratuity within 4 months. And then, yes, well, my lord, at that point of time, the interest portion, it was just barely given. Now, and then thereafter, that order was challenged in intra-court appeal, and that matter was also dismissed. Against that order, the respondent McAfee preferred SLP before the apex court, and then that matter also we have annexed, dismissed. And all this series of acts that has led to delay was basically the way we were compelled to drag to exert our right for claiming the gratuity, so far gratuity is concerned. Of course, leave encashment was also there, that was also allowed. But so far this matter is concerned regarding the petition, we are claiming basically the time taken ever since we were made to retire from the year 2004 on the basis of the Golden Handshake scheme. After that, a series of litigation where we were compelled to exert our right, and then matter. It was basically the delay that has been basically attributed is not on the part of the employee, we the employees. Now we are basically claiming the interest on the delay. We have got the gratuity after a long battle of the litigation, and then now we are claiming the interest. So far the interest concerned, the law basically provides. So far the section 7 of the Payment of Gratuity Act is concerned. Well, if I may be, yes.
How many petitioners are there?
95.
95.
95 petitions. Section 7, so subsection 3A. Subsection 3A. The relevant part is subsection 3A.
Yes, sir.
So, my lord, I have given the written argument also, but nevertheless, I am just placing my submission in briefs.
This matter has been heard earlier.
My lord, on the last occasion, the court was pleased to hear this gist of the matter, and the court had asked that to prepare the written argument, so that we also have supported with the judgments, so that it would be easy for the court to pass.
I don't have a copy of the written argument submitted by the petitioners, my lord.
Yes.
I could have been.
My lord, in fact, I don't know whether they are going to prepare the written argument or not, because I was of the view that they would also be presenting the written argument. In fact, it is just a synopsis only. Whatever.
But you relying on some authorities,
you know.
So,
yes, once you rely on some authorities,
yes.
then they have a right.
Yeah, the authority is concerned. It's from our own court. This own court, and some of the judgments are from the.
Give him a copy.
Yeah, I'll be giving you. I will definitely provide.
Do it now.
I just have to take the copy because I had given it a copy. I thought.
So let it be like this, Your Honor. If I may suggest, since they are relying, as they say, they're relying on some authorities, let them give you a copy, and in the meantime, in a week's time, I will also file rebutted to whatever citations they are giving, whether it's relevant, not relevant, and I'll also point then orally I can also supplement to what we're saying, so that will be more easy to grasp the entire thing, because now the issue they're not addressing, the issue according to me, my lord, it's whether pendency of any cases before the court would
tantamount to the
Would entails payment of interest.
Yes, yes. So that is the crux of the, because the
that
facts
could
are,
be that could be one of the issues to be.
they have to overcome that only.
But the only thing is that the matter has been laid to rest now. So far gratuity is concerned, the matter has been laid to rest. Payment of gratuity has already been made, including the relief encashment. So now what we are claiming is that we are claiming the interest delay.
Interest from the time, from the inception of the.
Yes, when we are made to retire.
Of the when you made.
When we made to retire, because at that point
till
of
payment of the gratuity.
Yes, because at that point of time the cabinet memorandum had mooted out where our statutory dues, so far gratuity and leave encashment was concerned, would be paid. But nevertheless, we had filed many representation since there were many grey areas, and subsequently matter had proceeded to controlling authority, and the controlling authority initially at one point of time they have annexed allowed that we are entitled to gratuity, and subsequently again they file a review, and the controlling authority had taken a U-turn, and thereafter the matter came to the court and started, and the initiation of the matter had taken place for payment of gratuity, where the single bench had passed the order for allowing us that we are entitled, that it is an establishment, we are entitled to gratuity. Against that order they have challenged in the intra-court appeal. Because these are the conduct on the basis of which the amount of delay which ought to have been paid at the first instance.
Whatever the case may be, there will be gallows of reasons. But what exactly is the legal issue to be decided is whether you're entitled.
The only point is this.
For that period,
yes.
Whether that ought to have been made part of your pleadings or part of your prayer initially.
Yes, my lord.
All these things.
My lord, even if it is not pleaded, but since the law provides that can be interest can be allowed, to that effect judgments is there. Our own High Court, the Supreme Court, a lot of judgments so have incorporated.
Fine.
My lord.
So we'll do it after a week then.
After a week, well, let them give me a copy.
This matter come on the 12th, if it's possible, because some series of matters it will take some time if it's possible, if this matter come up on the 12th as per the government.
My lord, the only concern for me is like Friday normally my cases comes up in the Supreme Court. So Thursday normally
12 is a Thursday.
Yeah, so Thursday normally we travel and then Friday do and come back. So it becomes a little difficult for me because 2-3 SLPs that's supposed to come up this coming Friday and the next Friday.
So we'll fix it on 16.
16, my
That's
lord.
Monday.
Yes. 16 would be appropriate, my lord.
Mr. Shulai, similarly you can make your file.
I'll make the submission on the basis of the report.
And the legal issue.
Learned counsel for the petitioner has submitted that the written argument has been filed as far as the petition is concerned. The learned counsel for the respondent.
I am respondent number 2, my lord.
And respondent number 2 has, however, submitted that he may be given a copy of the same so as to file, so as to rebut the same if so required in his written argument. This being the case, as paid for by the party, matter is listed on the next date. List the same on 16.
All right.
All right.
Item number 14.
Yes.
Please, Lordship. Lordship, as per the last order, service has been affected and respondent number 3, Your Lordship.
Respondent number 3.
And 4, Your Lordship.
It's here, Your Lordship. Respondent R3 is here.
Yes.
Respondent number 3. I've seen this order. This is the first time that I'm getting this.
Are you appearing? I mean, are you engaging a counsel?
I will appoint a counsel, and in the meantime,
Have you got a copy of the?
papers are the index and the papers given are not correct. So I can get a
Please.
Page 50 is not there.
You give a complete set.
Yes.
You see, when you
As given in the court, you give to us that.
when you
Let them give
when
a
you
complete set.
yeah, when you issue a notice, you be sure to be detailed. Give the correct papers.
My apologies.
More often than not, this thing comes up in court. Then one day is wasted only for that.
Arrange a counsel, sir.
Please do that. Please.
Respondent number 4 also is not represented.
Has submitted that the notice issued upon the respondent 3 has been affected. The respondent 3 has also appeared in person before this court today and has submitted that she may be allowed to engage a counsel to plead on her behalf. Another submission made is that the petition and the related papers supplied to the respondent 3 are incomplete, to which the learned counsel for the petitioner has submitted that he may be allowed to supply the complete set in course of the day. How long?
She has to file a reply, Your Lordship. So sufficient time may be given 3 weeks.
Respondent number 4 also is not represented, Your Lordship.
Oh, really? Who is respondent 4?
Long Vaishnav, Your Lordship. It is the headman of Slay Ular village, Your Lordship.
Okay, have you issued notice upon him?
Yes, Your Lordship. Service has been affected, Your Lordship, and twice we have served.
No, was it affected?
Yes, Your Lordship.
Have you filed affidavit of service?
No, Your Lordship.
Whether he has received a notice or not, then you file an affidavit of service to that effect.
I go to paragraph 2. Slide to more. Heading to respondent 3 nay. As far as respondent 4 is concerned, the learned counsel has submitted that the notice issued upon the same has been affected, inasmuch as the respondent 4 has received said notice. However, the learned counsel has prayed that he may be allowed to file an affidavit of service in this regard. Pray aloud. As prayed for, this is matter of the 3 weeks.
Let it be 3 weeks, Your Lordship. She has to file the reply now.
Fine.
Apply.
Item number 15.
Your Lordship, I seek some accommodation in this matter also, Your Lordship.
Nongri is the leading counsel here, Madam.
On pray made by petitioner, this is matter up to 2 weeks.
Item number 17.
May please, my Lord. My Lord, pray that the matter may be adjourned for today, my Lord, and be fixed after a week's time.
The counsel for the petitioner has sought for accommodation in this matter. As prayed for, this is matter up to 1 week.
Much.
Apply, Your Lordship.